Hello everyone, my name is Dewayne White, and today I would like to present to you on the impact of international law on cloud computing. First, I would like to give a brief definition of what cloud computing is. Cloud computing, it refers to the resources and services of information technology, and that includes software, platforms, and infrastructure. You see, unlike traditional on-site IT software and hardware, this is all made available to you via the internet. Cloud computing enables firms to take advantage of financial savings, cost sharing among others of a similar cloud, and staying efficient while the infrastructure of their information technology is consistently updated and upgraded by the cloud computing provider. As the largest world economy, the European Union is highly concerned about its competition in the world of digital technology. Cloud computing providers are required to gather personal information from users in order to serve them. Without such information, as far as the user profile, the cloud computing services would be inaccurate. So that's why it is very important to have the correct personal information from each user. So, for instance, a travel booking cloud-based website for employees may record the personal data about users. Such personal data includes their addresses and complete names. Cloud computing providers might also process or store personal information about the customers in its database and clouds. Cloud providers, they should develop an assurance that the data processing and storage complies with all of the rules and regulations in all appropriate jurisdictions. And that can turn out to be even more complex when data is processed and stored at a global level. This does not only occur in the home country of the cloud provider, but it also occurs in the home country of the customer as well. For instance, a CRM cloud-based database is likely to include the personal details, such as contact information about the customers of client firms. In certain situations, this complication could have the possibility of restricting the ability of the cloud computing provider to do business in various markets. Recently, a formal ethics opinion has been proposed and crafted by the North Carolina Bar. This was did mainly in collaboration with the ownership of using a practice management program under the practice of jurisdiction. According to the rules of professional conduct, a cloud computing program might be used by a company given that it provides the initiatives or taken to reduce the risk of unauthorized or inadvertent release of the personal information about its clients, and also to protect the property of the client. Such file data from the possibility of any kind of loss. As far as the laws and legality of the impact of international laws on cloud computing, the proposed laws were developed in collaboration with the governance of ABA, Legal Technology Resource Center, which provided counseling and guidance on the benefits of cloud computing. In Europe, the major obstacle in the use of cloud computing services includes the current legislation of data protection. The current laws were not considered to be comprehensive because they offered an option to member states to adopt and for them to follow only minimum standards. As a result of this, the poor standards of data protection eventually emerged, and a greater certainty has been created in the implementation and use of cloud computing technology. The implementation of general data protection regulation, also known as GDPR, is wide-ranging, and it has a list of cloud providers that are required to modify and change their contracts, processes, and services to meet the needs of each newly developed legislation. In all member states, a uniform approach will be provided by the GDPR to the law of data protection in the European Union. That requires GDPR to have an individual set of principles on protection of the data across the Union. The law basically substituted the current and appropriate national law of data protection that prompted ambiguity and confusion among cloud computing providers and its users. That law, at the same time, it immediately will be imposed on all member countries, and the existing data protection directive would not be considered appropriate anymore if that was the case and if that occurred. So the directive has a big impact on that. The law of GDPR ensures a unified strategy to the protection of data, and it cannot be weakened or changed by different member countries at the local level. Everything must be done at the global level. Cloud service providers welcome a massive change in legislation because it offers a unified privacy law around all member countries, and it does that by ensuring the ease and compliance and minimizing the operation cost that occurs in compliance with activities. This will enable the cloud computing providers to help businesses to expand their operation and compete effectively with each other. Cloud provisions that are set in states outside EEA and the European Union have to undergo a two-step test at the time when they require processing for the personal information of an EU citizen. First, there is a legal basis that must be established, and that is mandatory for the processing of data in a cloud and personal data transfer that goes on in the cloud. Secondly, an appropriate data protection level should be assured at the location of the cloud outside EEAU. For the second stage process, the contractual clauses as per standards of the EU is integrating corporate principles and protected harbor. That protected harbor should be appropriate. Now, unexpectedly, various data protection authorities and offices do not always make a clear difference between two fundamental steps. I do like to mention that 60 Article 25 FF EU DPD is appropriate about the second step. It is required in Article 25(1) EU DPD that personal data transfer to the third states should be prohibited by member states. This is mainly because of the reason that third states or third world countries lag behind in adopting and implementing and using the same legal protections unless the data transferred is approved by the European Commission or the National Supervisory Authority. B, one out of the different restricted exceptions apply. C, safeguards that have been approved are in place. So, to wrap this thing up, it is highly important for the companies to discern the policies of the cloud provider. This is mainly for the purpose of security audits, reporting, and the detection of intrusions. The cloud computing providers need to develop an assurance that the cloud provider interact with its users in each phase of the data oversight. This is highly essential to show compliance with the protection and data privacy laws, which usually would need the immediate notification of any documentation of data breaches of all initiatives taken to rectify the issue at hand. So it can be concluded that the cloud service provider should adhere to the policies, laws, and regulations of the country in which it operates in. This will enable cloud providers to smoothly run their operations in an efficient manner without facing any kind of hurdles in the country of jurisdiction. Following laws and regulations would help to develop and promote the better working environments for businesses. This concludes my presentation on the impact of international laws on cloud computing. Thank you for watching. Goodbye.